Last time I left you with this dilemma. A mother applies to court seeking permission to take her child on a 2-week holiday abroad. The father objects, not because he believes the child is unsafe, not because he fears abduction, but because he says the holiday clashes with his time that the child is due to spend with him. The mother says opportunities like this don't come along often. The father says a court order is a court order, so who should the court side with? The mother? The father? Or is there another solution? Today we're going to find out what happened. And this one is more difficult than it first looks because the mother has a point. This is a holiday, a childhood experience, a chance to travel, make memories and enjoy something special. But the father has a point too. There's a court order. The child is supposed to be spending that time with him. And his time with the child isn't disposable just because something else has come up. So does the holiday go ahead? Does the order come first? Or does the court find another way through? Before I tell you what happened, let me know what your instinctive answer is. Would you have allowed the holiday? Would you have refused it? Or would you have tried to find a compromise? You're watching Family Court, You Be the Judge. This is the series where I give you a family court scenario, you decide what you think should happen, and then I tell you what the court did. Before we go any further, the usual reminder, these are fictionalised family court scenarios created for education and discussion. They're not about identifiable people. Any similarity to any person, family or situation is entirely coincidental. I'm a Mackenzie friend, not a solicitor. I help people understand and prepare for family court, but this video isn't legal advice for your own case. Family court decisions turn on the facts, the evidence, and above all, the welfare of the child. So treat this as a way of understanding how these disputes might be looked at, not as advice about what you should do in your own proceedings. So let's get back to the scenario. The child lives mainly with the mother. The father spends regular time with the child under a court order, and that order includes time during the school holidays. So everyone knows where they stand. The mother has her time, the father has his time. The child has a routine. Then the mother gets an opportunity to take the child abroad for 2 weeks. It's a proper holiday, flights, accommodation, a chance for the child to go away, enjoy the sunshine and have an experience and see some culture that they might not otherwise have done. There are no safeguarding concerns. There's no suggestion that the child would be unsafe. There's no allegation that the mother wouldn't bring the child back. The issue is much narrower than that. The holiday overlaps with time that the child is due to spend with the father. The mother says, this is a special opportunity. The child will benefit from it. I'm not trying to stop contact, I'm offering replacement time. The father says, that isn't the point. There is a court order. The child is supposed to be with me. I shouldn't lose my holiday time because the mother has chosen to book something else. And because they couldn't agree, the mother applies to court. So the real question, at first glance, people often jump to one side. Some people will say, it's only a holiday, let the child go. Other people will say, no, a court order is a court order. What's the point in having one if you don't follow it? But family court is rarely that simple. The court isn't just asking, is the holiday nice? And it isn't just asking, does the father have a technical point? The real question is, what arrangements best promote the child's welfare? And part of that is looking at the holiday. But part of that is also looking at the father's relationship with the child, because a holiday might be valuable, but time with a parent is valuable too. Let's start with the mother's argument. Her position is that the holiday is a genuine opportunity for the child. It's not a relocation. It isn't an attempt to cut the father out. It's not a refusal of contact. It's a temporary change for a limited period. She says the child will benefit. The arrangements are clear. There are flights. There's accommodation, there's a return date. And she offers the father replacement time so that he doesn't lose out overall. That's a sensible argument. If there's no risk, no abduction concern, and the child gets a positive experience, the court may well ask, well, why shouldn't the child go? And where a parent has offered proper replacement time, that can help a lot, because the parent isn't just saying, I want this, and the other parent can just deal with it. They're saying, I recognise that there's an order, I recognise the other parent's time matters. Here's how I propose to deal with it. And that distinction matters a lot. But the mother still has a problem. The court order exists, and unless the father agrees, she can't simply decide that the holiday takes priority. A reasonable proposal is still only a proposal. It doesn't override a court order by itself. Now let's look properly at the father's position. And I think this is important because sometimes in these disputes, the parent objecting to the holiday is often painted as being difficult or petty. But that isn't necessarily fair. The father has a court order. The order tells him when the child should be with him. He should be able to rely on that. He may already have less time than the mother. He may have planned around that school holiday period. He may have booked time off work. He may have been looking forward to uninterrupted time with the child. He may have booked a holiday already in that same period. 2 weeks of the summer holiday can be significant. For some parents, holiday contact is the time when the relationship really gets room to breathe. It's not a rushed evening after school. It's not a weekend squeezed between homework, washing, and the next handover. It's proper time. Days out, lazy mornings, normal routines. The kind of time where the relationship develops. So when the father says a court order is a court order, that isn't just a legal technicality. He's saying my relationship with the child matters too. And he's right. His time shouldn't simply be treated as the spare time that can be moved whenever something better comes along. The court should not treat the father's time as disposable. And there's another concern. If one parent can book a holiday during the other parent's time and then say, well, it's booked now, that creates a problem because it rewards the parent who acts first. It can put pressure on the other parent to agree, and it can turn the court order into something much weaker than it should be. So the father's argument has real weight. So where does that leave the court? On one side, there's a holiday that appears safe, positive, and child-focused. On the other side, there's a court order and a father whose time with the child matters. And this is where the answer wasn't simply mother or father. The court looked for a middle ground. The court wasn't likely to say it's a court order, so the holiday is automatically refused. But the court also wasn't likely to say it's a holiday, so the father just has to accept it. The court had to ask whether the mother's proposal could be made fair, safe, and workable. And this is one of the things that I often help people with as a Mackenzie friend. Don't just tell the court what you want. Show the court your proposal actually works for the child. What dates are involved? What time is being missed? What replacement time is being offered? What information will the other parent have? How is the child's relationship with both parents being affected? That's often the difference between having a complaint and having a proposal. And courts need proposals, not just arguments. Has your view changed yet? Are you still firmly with mum? Are you still firmly with dad? Or are you starting to see why the court might look for something in the middle? The decision. So, what did the court do? The court allowed the holiday, but not as a blank cheque, and not because the father's time didn't matter. The court accepted that the holiday was a genuine opportunity for the child. There were no safeguarding concerns. There was no abduction concern. There was no evidence that the mother was trying to undermine the father's relationship with the child. But the court also accepted that the father's time was important too. So the holiday was permitted, but conditions were attached. The mother had to provide proper travel details, flight information, accommodation details, emergency contact information, the date and time of departure, flight details, the date and time of return. And the father was given clear replacement time, not vague promises, not, well, we'll sort it out later, organise it between yourselves, actual replacement time. So the child got the holiday, the father's relationship was protected, and the court order was being respected. by being temporarily varied rather than ignored. That's the key point. The holiday didn't simply override the court order. The court changed the arrangements for that specific situation. So what can we learn from this? Firstly, court orders matter. If there is a child arrangements order, it shouldn't be treated as optional. One parent can't simply decide to rearrange things because they found something they think is better, even if the child wants to go, even if the holiday is positive, even if the other parent is being frustrating. The order still matters. Second, court orders are not supposed to stop ordinary childhood experiences. Children should still be able to go on holiday. That's what's best for them. Children thrive on holidays. They should still be able to attend family events. They should still be able to have opportunities that sometimes require a bit of flexibility. The court isn't trying to turn childhood into a rigid timetable where nothing can ever change, but flexibility needs to be handled properly. That means notice, details, a clear plan, replacement time, and respect for the other parent's role. Third, the way that a parent approaches the issue matters. If mother had booked the holiday without asking and then presented it as a done deal, that may have created a very different impression. If she refused to provide travel details, that may have caused concern. If she offered no replacement time, that would have weakened her position too. Equally, if the father simply said no to everything with no willingness to think about a practical solution, that could make his position look rigid. And I see both of those sides of the story every day in my work as a Mackenzie friend. It's not about dad's time not mattering. It does. But because family court decisions are about the child's welfare, not about one parent winning a point against the other. And that is often where people go wrong. They arrive in court ready to prove the other parent is being reasonable. You don't take them to court for them being unreasonable. That's not going to work in child arrangements. The court wants to know what it is that you're seeking, not just that the other parent is not being reasonable. The stronger approach is often to give the court a solution, a clear, practical, child-focused solution. So what if the facts were different? Would the answer be the same if there was an abduction risk? Probably not. Would the answer be the same if the holiday was during school time? Maybe not. Would the answer be the same if the father had already booked his own holiday during that period? That could absolutely change things. Would the answer be the same if the mother had given no details and simply said, "Trust me"? That would be a problem. Would the answer be the same if this happened every year and the father's summertime was being constantly eroded? Again, probably not. So don't take from this episode that holidays always win. They don't. And don't take from it that court orders always block holidays. They don't. The answer depends on the facts, the welfare of the child, the nature of the holiday, the impact on the other parent, the replacement time, the notice, the level of cooperation, and whether the proposal is actually workable. In this scenario, the court found a balance. The holiday went ahead. The father's time was replaced. The child remained at the centre of the decision. So, did you get it right? Did you start off with the mum, dad, or the middle ground? And did your view change as the arguments developed? Let me know in the comments down below. And if you're finding this series useful, please like the video, subscribe to the channel and turn on notifications. It really helps. It helps the channel grow and it means you'll see the next scenario when it goes live. Because next time we're moving on to a very different kind of dispute, and this one is much more sensitive. A 14-year-old child tells both parents they identify as a different gender. The child wants a new name, different pronouns, and wants the school to recognise the change. The mother supports the child, the father opposes it. Not because he doesn't love his child, but because he believes a 14-year-old is too young to make such a significant decision. And caught in the middle is the child saying, "This is who I am." Both parents love their child. Both parents believe they're acting in the best interests. But they completely disagree about what should happen next. So who should decide? The child, the mother, the father, the school, or the court? Let me know in the comments down below. And next time, you'll discover what happened. Until then, you be the judge.